Well, good afternoon, everybody, and how wonderful to see people here on time. It's not even the Cambridge 5 past the hour yet. My name is Pippa Rogerson. I'm a professor here in the law faculty in private international law. I've also been true Cambridge through and through. I was an undergraduate at Newnham. I then had 3 years at what was then Coward Chance and came back to do a PhD at Keys, where I've stayed ever since, and I'm now, for my sins, master. But it gives me enormous pleasure to welcome you all to this third Cambridge Women in the Law event. The first one in 2019, in person, huge success. The second in 2021 had to be online, and it is really lovely to see us all back here in person now. There are lots of people who've been involved in the three events and in this one, and I won't name them, but thank you all very much for working so hard on it. We really have a fantastic afternoon this afternoon. First of all, we have Dame Vivien Rose in conversation. Then there will be time for tea and more discussion of what's been raised. And then we will return for a panel event on AI and law, the road ahead. Now, that event particularly shows the breadth and depth, I think, of what is going on in the law faculty and in the world, and how central legal academics can be to the most important work that is also being done by Ruth Ward as the Director of Knowledge at the Government Legal Department, by Catherine Apps at the bar at Essex Street. I have to say Essex Street, not Essex Court, in case I get confused, and by Imogen Ireland at Hogan Lovells, being joined by Dr. Amelia Leinart of the Cambridge Law Faculty. It is bringing women together absolutely at the centre of what's going on and important. Cambridge Women in Law originally in 2019 was celebrating 100 years from the Sex Discrimination Act of 1919, the Sex Anti-Discrimination Act maybe of 1919, and here we are 104 years later, and this is still a very important topic. Everybody's welcome, but this is the Cambridge Women in Law event. Now, this is where I have to do my air hostess impression. We're not expecting a fire alarm today, so if it happens, it will be something that we have to follow. The exits are down the front, and then when you get out, turn left, is the quickest way out of the building in an emergency, or the two exits at the back, you can go up and back, left up the way you came in. But as I said, this way is the quickest end of air hostess impression. So raising the tone, I hope, a bit. It is my honour to introduce Dame Vivien Rose, Lady Rose, or as I remember her from my time at Newnham Viv. Thank you so much for coming along to talk to us this afternoon, and I'll try and be appropriately deferential from here on. Lady Rose is currently the sole woman on the Supreme Court, although following some other notable Cambridge Law Faculty women graduates. Indeed, people who contributed both to the first and second events of Cambridge Women in Law, Dame Brenda Hale and Dame Mary Arden. And I seem to remember Eilish Ferren, professor of this faculty, remarking at the time of 2019, which was famously spider brooch occasion, Oxford can keep its numerous prime ministers. We in Cambridge are much more proud of our dominance in women members of the Supreme Court. So, Lady Rose, your path to the Supreme Court has not followed the usual straight ladder. Cambridge, via Oxford, the Bar, High Court, Court of Appeal and Supreme Court. There have been some absolutely fascinating diversions and civil and dedicated service, which I hope we will hear more detail about in your conversation with Sarah. You were a civil servant at the Treasury, and I remember very interestingly at the MOD. You were seconded to the Council of the Speaker of the House of Commons before becoming chairman of the Competition Appeal Tribunal, and hence on to high judicial office. So I am very much looking forward to hearing about that. I also introduce Professor Dame Sarah Worthington, who will be leading the conversation for us this afternoon. Sarah, until recently, was the Downing Professor of English Law, the Laws of England. She was a Fellow of Trinity. She came to Cambridge originally to do her PhD with Len Seeley, which is the first time I met her, but then went on to LSE after a stint at Birkbeck. She was pro-director at LSE and was awarded a DBE in 2020 for her services to private law. Along with being an academic, Sarah has been very involved in the British Academy, the British Museum, the London Business School, and is a bencher at Middle. So we have some remarkable women here. I'm very much looking forward to the conversation. Thank you.
Thank you, Pippa. That was a lovely introduction for both of us. This really is a conversation. We have an hour, and I hope that for the first part of it, I can ask the sorts of questions that you might ask Vivien, Lady Rose. And then at the end, you've got a chance to fill in the gaps, ask the questions that I didn't ask. And what I want to do is start with the Supreme Court and go in a loop where we touch on some of the high points in Vivien's life, and then return to the Supreme Court. So, starting with the Supreme Court, the day that you were sworn in. Go back to that day. So we see photographs of people dressed up in all this magnificent clobber, as my kids would say. What's your most distinctive memory of that day?
It was a wonderful day. It was in April 2021, so we were just coming out of lockdown, and I couldn't have a lot of people there because there was still a lot of social distancing, so I had to choose 5 guests only. So we were, but it was lovely because it was the first opportunity that my 11 colleagues had all to be in the same place since Lord Stevens had been sworn in the previous October, because everyone had been sitting remotely, as I had, from my dining room table, or what I call court number 1 at the Golders Green Civic Justice Centre. And so it was great just to be in town, in the court. And it was a very moving moment. I find the judicial oaths, whenever you take up any judicial office, you swear the oath of allegiance to the monarch and also the judicial oath. And it's one of, I'm sure it's not as old as it purports to be. It's a sort of slight Victoriana thing, but I find it very moving. And it was a wonderful occasion, and lovely. Some of the justices, of course, I knew very well, having grown up with them, as it were, in the High Court and the Court of Appeal. Of course, I didn't know the 2 Scots judges. I didn't know Lord Stevens. Now I know them very well. But it was a wonderful day. And I also specifically asked if I could go and have my photograph taken in Parliament Square by Millicent Garrett Fawcett, who, of course, one of the founders of Newnham College, and I very much value that photograph of me in my clobber, as you put it, standing next to her.
If you haven't seen that photograph, it is on the Newnham website, and it's the only photograph I've seen of a Supreme Court justice dressed up, other than for the start of the legal year. So I don't know whether you're the only person who managed to persuade a photographer to come outside.
Well, I'll ask. They can only say no. Of course, it depended on what the weather was going to be like. But no, they were happy for me to do it. So it was a wonderful moment.
It is a wonderful photo. And Lady Rose, Lady Rose of Colmworth.
Yes.
What's the significance of
Well,
that?
Colmworth is a little village just near St Neots, so not very far from here. When you're appointed to be a Justice of the Supreme Court, I don't actually get to join the House of Lords as the members of the Apex Court did when they were a committee of the House of Lords. So Lady Hale is a real baroness. I'm not a real baroness. It's a courtesy title. But nonetheless, one of the first things I had to do was get in touch with the head of the College of Arms, the Garter Principal King of Arms, and it is he who can tell me whether I can just be Lady Rose or whether I have to be Lady Rose of somewhere, and that depends on whether there's another or has been another Lady Rose. So there is another Lady Rose, has been another Lady Rose. Where can I be of? I said, well, what kind of place? To which he replied, this is all by email, it has to be a village or town that supports a barony. Well, I didn't find that particularly helpful. But I said, well, what about Colmworth? Adding, it's in the Doomsday Book. I thought, let's see if that cuts any mustard. Anyway, apparently Colmworth was fine, so I'm Lady Rose of Colmworth.
And that is where you live?
Yeah, we have I mostly live in London, but we have a weekend house.
So it's home and it supports a barony.
It does support a barony, yeah.
I didn't realise that extra requirement. That's news. So now I want to go back to your early life. When I first met Vivien, she was in the High Court, and I had been appointed as a Deputy High Court Judge, and she was appointed as my mentor. That was how I met Vivien. And I had a 6-year term, which I finished earlier this year, and by the time I finished my 6-year term, Vivien had been on the Supreme Court for 2 years. So this rise from the High Court to the Supreme Court was meteoric. I was very sad when she left and I had lost my mentor. But what I want to do is go right back to the beginning and see if there were any hints or inklings that this was the trajectory. So can we start with where you were born and parents, siblings, what were the life lessons that...
Yes, I've always been a Londoner. I haven't really flown very far from the nest. I've always lived in North London. My parents were both graduates. My father was a refugee from Germany just before the war, and my mother lived in Manchester. And they came down to London. My father worked for Marks and Spencer's all his career. So there were no lawyers in the family. I'm the middle of 3 girls. I went to the local comprehensive school, Kingsbury High School in North London, and I was very happy there. And it was a very good school, still is a very good school, very dedicated staff. And I always knew from the age of about 14 that I wanted to be a lawyer. I don't know where the idea came from, but I was always clear that I wanted to go to the bar. And I sort of followed quite a clear trajectory to do that. I read law here. Maybe if I'd known I was going to spend the whole of the rest of my life as a lawyer, I might have come to it a little bit later. But I did enjoy law as an academic subject, and I did enjoy school. And it was a family that placed a lot of emphasis on study and scholarship. My father had been at the LSE as a student, and they'd been evacuated to Cambridge. He'd been at Peterhouse during the war. So we had a Cambridge connection, and we used to come up and punt on the river every Easter. So there was no doubt if I had the ability, which I would aim for. So I came up to Newnham.
And you had to choose Newnham.
Yes,
This has this Millicent Garrett Fawcett link.
I'm not sure. At that time, Newnham didn't have its own director of studies. I was taught by Len Seeley and by Tony Smith. And they were our director of studies. And law was a very small, there were only 4 of us in the first year, lawyers, in my year. In my second year, then we did get a director of studies, Sally Woodward, and then the number of lawyers at Newnham expanded a bit. But it was good in that in the first year we were sort of farmed out everywhere because we didn't have any Newnham law faculty. So we tended to be farmed out to specialists in whatever topic we wanted to do. So I think we actually got a very good deal.
And got to know more people.
Yes.
And then you went to Oxford. So I have 2 questions here. One is obvious, why Oxford? But the other is, why a postgraduate degree? I mean, it surely wasn't necessary.
No, it certainly wasn't necessary. I wasn't sure whether I might have an academic life, but it wasn't really for me. How I ended up in Oxford was really coincidence. I was all planning to stay on here, although the postgraduate year was much more limited in terms of topics then. It was primarily international law, which wasn't something I was particularly interested in. But I happened to have a chat with Richard Fentiman, who had just arrived at Queen's in his first teaching post and was teaching me conflicts of laws. And I bumped into him and said, I'm not sure about what topics to choose. And he said, well, have you thought of going to do the BCL at Oxford, which I really hadn't. Anyway, he got busy and I ended up going to Brasenose for that year. And in fact, it was one of those odd things that turned out to be very influential in the rest of my life, because I made very good friends there who are still some of my closest friends. And that was where I first studied competition law, which then ended up being my specialism when I was in practice, and then my first judicial post. So having been a rather haphazard choice, in fact, it was a very lucky choice.
That's interesting. I could ask you, I suppose, who were the influential teachers beyond doing competition law, but I don't really want to ask you that. I want to ask you, knowing what you know now, when you look back on that undergraduate period and the postgraduate period, what do you think we could do more of and less of with our students now?
I think what was really great about the course here, which was rather different, as I understand it, from the Oxford jurisprudence undergraduate course, was that everybody went to all the lectures. And that was a great thing because it got you out of the college, you met your kind of cohort of lawyers, you got the basics dinned into your head of each topic. And I think that the undergraduate course appealed to me particularly because I do have a very practical rather than theoretical mind and approach to legal issues. And some of my colleagues on the Supreme Court have a much more academic approach to things and much more drawing out the principles. I've always seen law as a way of facilitating people to do what they want to do and problem solving. So I think that the Cambridge undergraduate course suited me for that. But whether it would suit someone equally who did have the more sort of philosophical approach to things, I'm not quite sure. But it was good. It was good for me. Yes.
So you then went to the bar.
Yes.
And you said when you were talking about being at school that you knew from the beginning you wanted to be a barrister. I know from years and years of teaching, quite a lot of students worry about that choice. And they're not quite clear how to make it because being at university is quite different from doing either of those things. Why were you so sure?
I thought I would enjoy the sort of performative part of it. In fact, I didn't, and that was why I left after 10 years. But I think that there were then quite a lot of prejudices against the soliciting branch of the profession as not being as intellectually rigorous or demanding or as interesting. I don't think, in fact, that that's true, but that was the sort of the perception. Yes. And there was also, that was really at the time all that was on offer. You either applied to one of the Magic Circle firms or you went to the bar. I think that one of the things I've learned in my career, and also one of the things I try and emphasize when I speak, as I do, to students, whether they're sixth formers or university students, is actually there is so much more out there as a legal career than just those two options. But it was quite limited in those days, and of those two, I preferred the idea of going to the bar, even though I realise now I didn't have much idea of what it was actually going to be like. And the bar is very different depending on whether you go into the criminal bar side of things or the commercial side of things. And I went towards the commercial side, which was the right choice for me.
So I suppose one of the lessons is that you were brave enough to leave. I imagine that quite a lot of people head down a particular route and they've gone so far. You said you were there for a decade. They've gone so far that it's quite hard to say, I'm going to jump off.
Yes, and it was more surprising in those days. I think careers have become much more fluid and people do move. But in those days at the bar, if somebody wanted to move to a different set of chambers, everyone would think, my goodness, what could possibly have happened? Or a different law firm. It was a sign that something must have gone very seriously wrong. So it took me a while. I very much enjoyed being a barrister as much as I did it, because when I had something quite difficult to do in court, they would appoint a more senior QC, as they were then, to lead me, and I didn't actually have to do the court bit. But I realised that I really didn't enjoy being in court, and that's quite a disadvantage if you're a rising barrister, let's face it. I got very, very nervous beforehand, and nobody talked about these things in those days. And I was always quite, people said, why are you leaving? Because I was making a good living at it. And I said, well, I find it very stressful. I get very nervous beforehand. And they said, yes, well, so do I. But I obviously wasn't getting the compensating buzz that they were getting from actually doing the job. And the last case I did was with the late and much missed Ginevra Cause, who was a wonderful barrister, delightful woman, and one of the few really successful, at that time, really successful commercial silks. And I remember this so clearly, sitting there, and when I met her, that's what I'm going to be like. She's my role model. And then I remember sitting with her saying, well, what have you got coming up in the term ahead? And she was going up to Manchester to do this 3-day trial and this hearing. And I remember sitting there thinking, I would be completely wretched if that's what the next few months held in store for me. But that is where I am heading. And if I don't want to get there, I'd better switch.
Change direction.
So then what was I going to do? Would I give up the law completely and do something completely different? And I had some good careers advice, which is don't give up the law. You obviously really like the law. You've invested a lot of time and energy into it. It's being a barrister you don't like. I joined the government legal service, which was working always in an advisory capacity. So I avoided the whole stressful litigation side of things. Yes.
Well, I want you to say more about the government legal service, because I don't know if you had the same reaction as me, but part of me thinks, well, probably not a lot of law, a lot more policy and a lot more constraints on what you can do, because it depends who's in government and what their trajectory is or the route they're on. And yet, I've only made a note of 3 areas. So you were in Treasury doing drafting, and then you were in the Ministry of Defence, which Pippa mentioned, which sounds absolutely fascinating, and then counsel to the Speaker, which also sounds absolutely fascinating. And who knew that the government legal service could be quite so interesting?
Yes, I think as a barrister, I'd done work for public bodies and had been instructed by Treasury solicitors, but I hadn't realised that there was this whole other, thousands of them now, I think, government lawyers all working away in the individual departments, advising the department on whatever it is they want to do. And when you realise it, you think, oh, well, yes, of course they must exist. But it is very interesting. There is a lot of legal content to it. And in fact, I think you get a lot more responsibility at a much more junior level than you would in a big city firm. And you also, one of the great selling points of the government legal service is that you do get every 3-4 years to move to do something completely different, because they recognise what I think a lot of lawyers in private practice don't recognise, which is that legal skills are actually generic. They're not tied to any particular legal topic. So if you can read legislation, if you can read case law, if you can read EU regulations and directives, you have a rough idea in your mind what the answer's likely to be, and you can apply those skills of fact gathering, sorting through what's relevant, what's irrelevant, to any topic. And the government recognises that, I think, far more than private practice does. And actually, it's a very good training for being a judge, because when you're a judge, every day, practically, it's a different legal topic, particularly in my work at the moment. I mean, it is literally anything.
Yes.
And in the skills list that they have for the judiciary, it's always there. You have to demonstrate the ability to get to grips with a new area of law quite quickly. And for someone who's just worked in the pensions department of wherever, or in criminal law or whatever, for the whole of their career, they find that much more frightening a prospect than I did, because I did work for 5 years in financial services in the Treasury, and that I joined the government legal service right at the beginning of '96. So we had a year and a bit of the sort of tail end of the John Major administration, where they couldn't really do anything because they didn't have a big parliamentary majority. Then in May '97, of course, in comes New Labour, and they wanted completely to revise the whole system for regulating insurance, financial services and banking. And we had this mega act, which became the Financial Services and Markets Act. And I was on the bill team for that. And there is kind of policy involved in that you sit with the policy people and you work out from the very mega strategy overview right down to the very detailed level of what's got to be in the bill. Because part of my role was then not only advising the policy people and putting up briefing to ministers to take all the myriad decisions that there are, but then drafting the thousands of pages of instructions to Parliamentary Counsel to actually prepare the clauses, seeing whether what comes back works, piloting it through the House of Lords and the House of Commons. I mean, it was a fascinating exercise. And then off I went to the Ministry of Defence, really completely different. I joined the Ministry of Defence at the beginning of 2002, so just after the main hostilities in Afghanistan. And of course it became clear quite soon that there was going to be another war in Iraq, and so it was preparing for that. So absolutely completely different area of the law. But you just apply the same skills that you've picked up along the way.
Fascinating, absolutely fascinating. I'm sure there'll be some more questions on that. But you're in the middle of this fascinating mix, and then you decide you'll do something else.
Yes.
So how did that happen? You know, you're happily in this interesting
I was
career,
very happy in the
and you think you'll go and be a
The
judge?
difficulty with, I mean, I'd always had in mind when I was a barrister that I would like to be a judge, but when I left practice at the private bar, that I thought meant I would never be a judge, because in 1995-96, all judges, the senior judiciary, were drawn from senior silks. And that was my one big regret, actually, of leaving practice. And I thought I was saying to myself, well, am I really prepared to stick this out as a barrister, knowing that I'll be actually quite miserable for another 10, 12, 15 years, in the hope that someone will tap my shoulder and say, would I like to be a High Court judge? And I thought, no, I'm not going to do that. So when I joined the legal service, I thought I'd said goodbye to that. But then in the early 2000s, there was a complete revolution in how judges are appointed. The Judicial Appointments Commission was set up. It was no longer the sort of tap on the shoulder system. It was all open competition, and the pool from which judges were drawn was also widened. And the then Treasury Solicitor, Dame Juliet Weldon, she fought very hard for employed lawyers and government lawyers to be able to eligible for judicial appointment. And as soon as I heard that, I thought, well, right, so what do I need to do? And it was also that I'd got to a level, I'd got to be a grade 5 lawyer, and I really enjoyed that. But I was aware that at the levels above that, the legal content of the civil service job is reducing, and it's a lot more management and strategy. And lots of lawyers really love that, but I didn't feel that was for me. I wanted to keep primarily legal content. So I went to see Juliet Weldon and I said, look, now it's all opened up. I really think I'd like to aim to be a High Court judge. And she said, well, we will support you. And it took me, then I was a grade 5 lawyer in the Ministry of Defence. It's not a very good jumping off point. So it took me 8 years of quite careful planning to get myself into a position to apply for the High Court bench. So that involved getting a part-time judicial appointment, because most full-time judges have already, almost all, have already done some part-time judicial work as you did. And that gives you a chance to see whether you like it, whether you're any good at it. So I thought, well, I'll look for a post which is something I know about, which was competition law, which I'd specialised in when I was a barrister in private practice. So I applied for the Competition Appeal Tribunal, and that was my first judicial post. So when I went to work in the House of Commons in the Office of Counsel for the Speaker, that was 3 days a week. So I moved to work part-time in the government, and then I did 2 days a week in the tribunal, and I did those for a couple of years, 3 years, I think, until I was sure that the judicial side was what I wanted, and then I left the civil service.
And recorder in the criminal court?
Yes, so once I'd decided that that was what how I wasn't going to go back into the civil service, I then started applying for other judicial posts, because the good thing about judicial work is that you usually get your first job in something that you know a bit about, but once you've got some judging under your belt, then you can move across to do judging pretty much anywhere. So I joined the Charity Tribunal and the Environment Tribunal, and then I applied to be a recorder in the criminal court. And that used to be the sort of traditional first rung of the judicial ladder for people who were going up to the High Court. But all these rungs had all nobody knew now under the new dispensation what you actually needed to do. So it was all kind of a little bit random, but I thought, well, I'll try and be a recorder. Partly because I thought, having been a lawyer all my career, I don't really want to get to the end of the career and not have any contact with the criminal, not the criminal fraternity, the criminal legal world, because that's what most people think of as the law. So anyway, I applied and I did that. I didn't do it very long, because then I became a deputy High Court judge. But I did, the good thing about it is, well, my husband said you bring home much more interesting stories from a day in court after you've sat as a recorder than anything else that I've ever done. And also, it's just such a weird thing to do. And also, I thought, well, every time I got through a 2-week period of sitting without having made some most awful mess up, and I thought, I can do anything, bring it on. If I can be a recorder in the Crown Court and sentence someone and harrow Crown Court of 5 years in prison, I can do anything. Nothing will scare me now.
I think it must be quite hard. So I'm a commercial lawyer through and through, but to be sitting in judgment and sending people to prison, Quite tough.
Yes, it is, but you know, you have to be prepared to do that if you're going to get them to take the job. So, and they've usually done something pretty terrible. But yes, it is. I mean, I think the difficulty with the sitting in the Crown Court is that the jury is this sort of 12 individual people who have to be gradually brought along with you and to keep them all in place and to get a verdict from them. And that, I mean, even I only did cases for 2 or 3 days. I am amazed at my colleagues, you know, Sir James Goss, who just presided over the Lucy Letby trial, to keep that jury together over that 10 months, and then for them to bring in verdicts where they were not agreed with some, they acquitted some, that, you know, so they had really clearly gone through every individual case.
Yes.
And that, to achieve that as a judge is an extraordinary feat, I think. And the thing about the jury is it's very, and the criminal court, it's very unpredictable. Every recorder's heart sinks where the usher comes in. Oh, you're on there's a note from a juror. And this can be anything. It may herald the complete collapse of the case. It may be nothing. It may be anything in between that. But that, oh, Your Honour, we have a note from a juror, strikes fear into the heart of every judge, I think.
Makes commercial law sound very predictable. I'm going to have to skip a few questions, I'm afraid, but I hope you'll pick them up in the time that you get to ask questions. So can we say, okay, you are the recorder and the Deputy High Court Judge, and then appointed full-time to the High Court. Yes. And in those roles, apart from the tribunal work, you're sitting by yourself.
Yes.
And then you go to the Court of Appeal, and you're in a group of 3, and then Supreme Court, and you could be, you know, 5, 7, whatever. What were the biggest changes in that transition for how you operate?
Yes. I did like being in the High Court because I do like to be in charge. You might have gathered that already. And I do find it a bit difficult not to be in charge, but I'm getting used to it. And yes, so there's a very different dynamic. The Supreme Court's very different because 5 is very different from 3. And also because there are only 12 of us in the Supreme Court, whereas there are 35, 38, whatever in the Court of Appeal. In the Supreme Court, we're all sitting with each other all the time in slightly different combinations, whereas in the Court of Appeal, you can go for, you know, weeks or a month and then come across someone you haven't sat with for a while. So it is a very different dynamic. It's very, I mean, the thing, when I joined the High Court, because I've been out of the flow of the path that everyone else had taken, I didn't know anyone amongst the judges. I didn't know how they were going to react to me, having come from a very different background. There were some things I predicted about the job, which was it would be very challenging and intellectually interesting. What I didn't realise was how wonderful all my colleagues would be. They are such a fun bunch of people. And not at all like I feared they might be. So that was a very pleasant surprise, and we all get on very well. And I think it's because in the Court of Appeal and the Supreme Court, you do actually sometimes, well, you do quite often disagree with each other. I mean, dissenting is much more common in the Supreme Court than it was in the Court of Appeal. But because of that, and because you know that you have to then move on, everything is very supportive, very polite. So whenever you send round a draft judgment to the panel, everyone, oh, thank you so much for your marvellous, clear, helpful judgment, with which I think there are these 15 things which you need to change. But and at first that kind of slightly spooked me because I felt, well, I really have no idea how genuine this is or how well I'm doing. But then I realise, actually, in order for everyone to get over the occasional tussles that we have about the result or about the reasoning, it is all conducted in a very polite, very non-bitchy environment. And I really appreciate that, because I have friends, who work in sort of horrible offices where everyone's and I know how terrible and soul-destroying that is. And that has never been my experience in the judiciary. They're a great bunch of people.
I certainly found that part-time. It was, you think as an academic that, of course, universities are going to be the ultimate in environments where people are, friendly, supportive, etc. So for me, it was a really pleasant surprise in the very part-time space. So this is women in the law.
Right.
Can't avoid doing this. I want to ask you 3 questions about your role as a woman judge. One about you, and then one more generally, and then one other more practical one, since you're a practical person. So first of all, about you. I mean, quite a lot of what you've said makes it very plain that you've had quite a different trajectory from most people. So there you are on the Supreme Court. You're the only woman at the moment. There were more before, and I assume there'll be more afterwards. But you are the only one, and you're almost the only one with such a different background. Do you feel sort of responsible for making the diversity thing work, just so that the practice keeps on going?
I think every woman who reaches a senior position now, even now, feels a bit of that responsibility not to mess it up, because you are kind of a bit of a standard bearer. I don't feel that my colleagues treat me differently, or I've never had any sense, and throughout my judicial career, I've always felt when I was in the High Court or the Court of Appeal, or now, I get my fair share of the exciting cases. You might think that in the Supreme Court every case is an exciting case. It's not true. There's quite a lot of sort of fairly mundane work as well, but I feel I've always had my shout of the cases, the high-profile cases, and that. And I think it is. I think I do feel that responsibility. When I started at the Supreme Court, I felt in a way, when I joined my chambers, I was the first woman ever to be taken on by those chambers. So I was the only woman in chambers. And this was in the early 1980s. And this was a very weird time. And it was a weird thing for them, and it was a weird thing for me. And for the first 6 months, I just spent the whole time, this is when I was just starting out as a junior barrister, thinking, well, I mustn't say that. Would I say that if I was a man? Would they have said that to me? And you can't actually live your life like that. And I've kind of let that go, and I am just me, and they have to make of it what they want. And they're all very strong personalities, as you might expect in the Supreme Court. And I don't feel, I mean, in those days you got by really by everybody absolutely completely ignoring the fact that you were a woman. I mean, it was just never mentioned. There was nothing ever said about it. And you kind of took that on for yourself as well. But I don't feel now I have to do that. I mean, it's always much nicer to have women colleagues, and I have 3 judicial girl chums who we meet up every few weeks for dinner, and we have a good old natter, and I really value that, and I'm very glad that we set up that, because I do miss female company, of course, but there it is. Someone's got to do it.
Yeah. So perhaps having dinners leads into the next question. The state of women in the judiciary. So certainly in Cambridge, and especially at Trinity, we were very pleased when Sue Carr was made the first woman Lord Chief Justice, because she had been a student at Trinity.
Yes, well, I think that's a kind of a good... I think the state of women can be, Sue is a good exemplar of that, because yes, she is shortly going to be sworn in the 750-year history of this role. She will be the first woman Lord Chief Justice. And the Times newspaper article reporting this opened, Dame Sue Carr, mother of 3, is going to be appointed. Right, so amongst the senior judiciary sisterhood, which is a close-knit and loving band of women, there was a lot of discussion. What do we make of this Dame Sue Carr, mother of 3? Goodness me. So you can either think, oh, really, even now women are all defined in their family role and their caring responsibilities, and haven't we got past that? And I'm sure when Ian Burnett was appointed, they didn't say Sir Ian Burnett, father. I have no idea how many children Ian has, but I'm sure that was not what they said. But on the other hand, the fact that Dame Sue has got to where she has and brought up 3 children, one of whom got a first at Newnham, was an enormous achievement because of what I was describing, because the professions, I'm afraid, have made very little adaptation in order to facilitate women getting ahead in their careers. When I joined, when I qualified for the bar, which is in 1984, it was already half men, half women qualifying, and everyone thought, well, 10 years' time it'll be half the silks will be women, 20 years' time it'll be half the judges will be women, and that has absolutely not happened. So in a way, I think, well, yes, it is a sign of her extraordinary achievement that she is Dame Sue Carr, mother of 3, about to be appointed to the Lord, to be Lord Chief Justice. But there's, I mean, I don't know whether that's getting any better.
So if
I
you could do
that it's
one thing?
Well, I think that this opening up of the pool of people who can qualify is very important. And I think that what would make a big difference would be if more solicitors could make their way to the senior judiciary. And what strikes me is that whereas sets of chambers regard it as a great honour if one of their senior members becomes a deputy high court judge, becomes a recorder, and although it makes a dent in the chamber's income for them to take 6 weeks out to do this judging malarkey, they still regard it as very good. Whereas I don't think firms of solicitors either have any policy about encouraging partners to do that or make it available to people. And I think that if the senior people in solicitors' firms, I know in the government legal service they're making steps towards this, or in any big organisation which employs lawyers, if they encouraged people by allowing them the time to do it, by allowing them to take mentoring opportunities, then I think that is a big cadre of women in very demanding legal positions who would be very good judges at whatever level, and then one wouldn't be so dependent on the small number of women who actually fight their way to the top of the bar. I don't
Be
know
told.
Anyway.
So you could all do something.
Yes.
I could keep on going, but I must give you a turn. Okay, before we close, this has all been very serious and we've traversed all sorts of interesting things. 5 quick questions.
Okay.
You said you're good at making decisions quickly.
Yes.
City or country?
City.
Theatre or concert?
Theatre.
Hearing cases or writing judgments?
Hearing cases.
I thought that would be the truth. Novel or a box set?
Oh, that's difficult. Can I have one of both?
This is not Desert Island.
I do. Yes, I do. After by the time I get to about 9:30 at night, after a long day, my brain is a bit frazzled. So I do watch quite a bit of television.
And then I gather you're going to Newnham tonight.
Yeah.
Port or claret?
Claret. Champagne, I think.
I didn't even have to ask you to say thank you. I hope you have enjoyed this as much as I have, and you've had a peep into Vivien's absolutely astonishing and varied career. It's been a pleasure to be here with you and with you, Vivien.
Thank you.
Thank you. Thank you all.